The Biden administration wants to wipe out $400 billion in student debt, but the court's conservative majority questioned its power to do so. 6 Republican-dominated states, Nebraska, Missouri, Arkansas, Iowa, Kansas and South Carolina, and 2 individuals sued to stop the plan. The Supreme Court's conservative majority seemed deeply skeptical on Tuesday of the legality of the Biden administration's plan to wipe out more than $400 billion in student debt, heightening the prospect that the justices would thwart efforts to forgive the loans of tens of millions of borrowers. Chief Justice John G. Roberts, Jr. indicated that the administration had acted without sufficiently explicit congressional authorization to undertake one of the most ambitious and expensive executive actions in the nation's history, violating separation of powers principles. "I think most casual observers would say," the Chief Justice said, "that, if you're going to give up that much amount of money, if you're going to affect the obligations of that many Americans on a subject that's of great controversy, they would think that's something for Congress to act on." The court's 3 liberal members said Congress had already acted, by passing a law in 2003 that authorized the Secretary of Education to address emergencies. "Congress could not have made this much more clear," Justice Elena Kagan said, adding, "We deal with congressional statutes every day that are really confusing. This one is not." By the end of about 3.5 hours of arguments in 2 separate cases, the court's conservative majority seemed likely to dash the hopes of the 26 million borrowers who have already applied for loan relief, including millions who have received approval. If the administration is to prevail, it would probably be on the ground that none of the plaintiffs in the 2 cases had established standing to sue, but that outcome did not seem likely, either. The Chief Justice, joined by other members of the court's 6-member conservative majority, invoked the major questions doctrine, which requires that government initiatives with major political and economic consequences be clearly authorized by Congress. There was something close to a consensus that the debt forgiveness program qualified as major. "We're talking about $500 billion and 43 million Americans," Chief Justice Roberts said, referring to the number of affected borrowers. Justice Samuel A. Alito, Jr. indicated that the ordinary colloquial meaning of major questions encompassed what the government proposes to do with student loans. Even Justice Sonia Sotomayor, a liberal, said the sums involved were legally significant. "That seems to favor the argument that this is a major question," she said. Hundreds of protesters outside the court, many of whom were college students from across the country, underscored that point. Mr. Biden's plan would relieve them of vast amounts of debt, they said. Kayla Lightfoot, a sophomore at the University of Mary Washington in Fredericksburg, VA, described the prolonged court fight over the program as stressful. "I'm truly just trying to stay focused and keep on going," she said. The administration was spurred to act because of the pandemic and its lingering effects. The law the administration relied on, the Higher Education Relief Opportunities for Students Act of 2003, usually called the HEROES Act, gives the Secretary of Education the power to waive or modify any statutory or regulatory provision to protect borrowers affected by a war or other military operation or national emergency. Chief Justice Roberts and Justice Clarence Thomas were skeptical that the words waive or modify allowed outright cancellation. "It doesn't say modify or waive loan balances," the Chief Justice said. Justice Brett M. Kavanaugh said that Congress could have in 2003 referred to loan cancellation and loan forgiveness, and those are not in the statutory text. Later, though, Justice Kavanaugh described waive as an extremely broad word, adding that, in 2003, Congress was very aware of potential emergency actions in the wake of September 11. Ms. Prelogar noted that the Trump administration had also relied on the 2003 law. In March 2020, President Donald J. Trump declared that the coronavirus pandemic was a national emergency, and his administration invoked the HEROES Act to pause student loan repayment requirements and to suspend the accrual of interest. The Biden administration followed suit. As of April, the payment pause has cost the government more than $100 billion, according to the Government Accountability Office. That has been an economically significant program, Ms. Prelogar said of the pause. It's currently costing the federal government more per year than this loan forgiveness plan would cost the government annually. In August, the administration said it planned to switch gears, ending the repayment pause but forgiving $10,000 in debt for individuals earning less than $125,000 per year, or $250,000 per household, and $20,000 for those who received Pell Grants for low-income families. The nonpartisan Congressional Budget Office has estimated the plan's price tag at $400 billion. In separate cases, 6 Republican-led states, Nebraska, Missouri, Arkansas, Iowa, Kansas and South Carolina, and 2 individuals sued to stop the new plan, relying on recent decisions employing the major questions doctrine. In June, the Supreme Court invoked the doctrine in a decision that curtailed the Environmental Protection Agency's power to address climate change. Without clear congressional authorization, the court said, the agency could not act. The court also ruled, on similar grounds, that the Centers for Disease Control and Prevention was not authorized to impose a moratorium on evictions and that the Occupational Safety and Health Administration was not authorized to tell large employers to have their workers vaccinated against COVID-19 or undergo frequent testing. The first question in both cases is whether the plaintiffs have suffered the sort of direct and concrete injury that gives them standing to sue. The point of the standing doctrine, Justice Ketanji Brown Jackson said, is to allow the political branches to hash this out without interference, from a torrent of lawsuits brought by states and entities and individuals who don't have a real personal stake in the outcome. Justice Kagan said it was significant that the loan authority itself had not sued over the debt forgiveness program. Usually we don't allow one person to step into another's shoes and say, I think that person suffered a harm, even if the harm is very great, she said. If Missouri really controlled the loan authority, Justice Amy Coney Barrett asked James A. Campbell, Nebraska's Solicitor General, who represented the states, why didn't the state just make Mahela come then? Mr. Campbell said that it was a question of state politics.